a bylaw in Calgary that prohibits specific topics from being protested too close to libraries or recreation centers. This is a bylaw that we at the Canadian Constitution Foundation believe is unconstitutional, and that's why we have brought a legal challenge to the bylaw. Now, Joanna, there is some case law on these so-called safety zones or safety bubbles. For example, around abortion clinics, there have been cases around physician homes, hospitals, and schools. How do you think libraries fit into that equation? Are libraries and community centers inherently different?
So yes, I think first of all, they are. I think libraries and community centers are what we call third spaces, apart from home and work, where people go to engage in civic activity. They're community spaces. And the second point is that some of the other spaces that you already mentioned, like hospitals, abortion clinics, they already do have specific, like for example, there's a criminal law against preventing somebody from accessing a hospital. And there's already laws, governing incitement or blocking people from accessing certain spaces. So I think it is very different, and it's very dismaying to see this type of intrusion into these types of community spaces.
So if a community center or a rec center or a library, if the bylaw removed the content issue, Yoav, if the government said instead of none of this topic being protested near a library, if they just said you can't protest near a library at all, do you think that that could be justified under our Constitution?
It's my opinion that it's not, because the test for whether the freedom of expression applies to protected expression in a particular forum depends on the class into which the restriction falls. So you can't necessarily, you're limiting expression by limiting the forum in a lot of ways. So you're not allowed now to protest in libraries at all, right? That is a limit on expression as far as I'm concerned.
Yeah, I have to agree with you both. I mean, the nature of a library or community center, these are places where quite literally political debates are hosted. They will invite authors on controversial topics to give talks. Community centers are often where municipal, federal, or provincial debates between candidates are taking place. The notion that you could prohibit protests around environments where the very purpose of the environment is to explore ideas and engage in debate is preposterous to me. So, Yoav, we filed this notice of application for judicial review. Where do things stand now? What exactly are the next steps?
So, assuming that we receive the records of proceedings, it's important for whoever it is that's waiting for the outcome of this to understand that we're not here to do these big cross examinations and have Perry Mason moments or Matlock moments as people expect. What usually happens is there's a few different types of outcomes on a judicial review, where the reviewing court finds that the government body or the tribunal at issue had no jurisdiction to make the specific decision. The decision is set aside and the local government is not permitted to revisit it. Now, that's not what we're saying in this. We're saying that they do have the power, but what we're saying is that the way in which it was done, the grounds and the specific decision-making process, along with the law itself that they put in, was fundamentally flawed. And so what happens with that, assuming the court agrees with our propositions and our position, essentially what will happen is they will send it back to the tribunal from which it came, and then the tribunal will have to revisit the issue, obviously with the guidance of the court decision that comes. So there's a saying, success on judicial review is usually not the final issue on the matter.
That's all the time we have. I want to thank you both very much. We've heard today about a new bylaw in Calgary that restricts protests based on the content of the protest. This is an unconstitutional law that unjustifiably restricts the right for Calgarians to protest. It is not for the government to pick and choose approved subjects for protest, relegating unacceptable views to a corner. That's why we at the CCF are challenging the law. What's your take on the law and our challenge?